Welcome to Trending Unpacked, the show where we explore the stories behind the trends shaping our world.
And, often the trends that really matter, the ones with deep impact, aren't the flashy ones. There's sometimes these dense technical terms.
Yeah, exactly. Terms that suddenly just explode out of like a legal brief or a courtroom.
And into the mainstream conversation. That's often where you see the real shifts in power happening.
Absolutely. And today we are definitely going to unpack one of those. It's a concept that sounds, well, pretty imposing, very technical,
Hmm.
but it's somehow become one of the hottest political buzzwords, really, of 2025. We're talking about plenary authority.
Right. Plenary authority. It's a term that's been around in constitutional law for, well, centuries.
Centuries, wow.
Yeah, but it's suddenly trending, as you say, because the current political climate is really pushing the boundaries, testing the limits of governmental power.
In some really critical areas, too.
Across several, yeah, very critical areas.
That really is the heart of it, isn't it? We've seen this term, plenary authority, being invoked and, frankly, picked apart in some incredibly high-stakes situations.
Definitely.
You hear it cropping up in Supreme Court discussions, right? When they're talking about the actual legitimate boundaries of executive power.
Yeah, exactly. How far does that reach?
And then there are the huge debates around border control, immigration policy.
Always a flashpoint.
Yeah.
And the scope of federal power there is central.
And most recently, you see it tangled up in all these controversies around election law. That age-old tension, really.
Yeah.
State control versus federal control.
Fundamentally, yeah. And what makes this specific term, plenary authority, so relevant right now is how it's moved.
Moved how?
Well, it's this complex legal idea, right?
Yeah.
It defines essentially absolute governmental power, but in a specific domain.
Okay.
And it's been sort of ripped out of its academic, its legal context.
And just dropped where?
Right into the digital town square. Social media, news commentary.
So everyone's suddenly a constitutional scholar.
Well, not quite, but you see journalists, you see regular people online actively trying to grapple with it. What does plenary authority actually mean for democracy? For, holding power accountable?
Which is exactly what we're going to do today. That's our mission.
Right.
We want to unpack this concept, get a handle on its historical significance, its weight, and really figure out why, right now, in 2025, plenary authority has become this perfect kind of shorthand.
Shorthand for what, do you think?
For these much broader cultural arguments we're having about who really holds the power, who's got the levers of control.
Yeah, that's a great way to put it.
Okay, so let's unpack this then. Starting with the basics, the fundamental definition. It really does sound like a concept describing, well, unstoppable power, plenary authority. What does that actually mean in legal terms?
It sounds immense, and the definition really does aim high.
Yeah.
At its core, plenary authority refers to essentially complete and absolute power.
Complete and absolute. Wow.
And this is crucial over a particular defined area of governance.
Okay, so not everywhere, but total control within a specific box.
Exactly. If a branch of government, say Congress, has plenary authority over a subject, it means it has the maximum possible jurisdiction, the full authority to regulate, to legislate, to enforce rules in that specific field.
Complete and absolute. I mean, those words alone sound like red flags in a democracy, right? Our whole system is built around limited government.
It is.
So how can a term that intense even exist within a system based on, checks and balances, inherent limitations?
Well, that's the crucial paradox, isn't it? In constitutional law and administrative law, too, what it means is that a specific government branch or maybe a level of government gets full decision-making authority without needing additional approval from other government bodies, but critically at that same jurisdictional level.
Ah, I see. So it's about clearing the decks at one level, establishing who's in charge within that sphere.
Precisely. It's about establishing clear, undivided jurisdiction for a specific topic.
So it's more about the scope of the power, not necessarily that the power itself is totally unlimited in its actions.
That's a much better way to think about it. Yes.
So if an entity has plenary authority over, let's say, Area X,
Right.
They get the final undisputed say on Area X, but crucially, they still have to play by the bigger rules of the game.
Exactly. The Constitution itself. They can't violate those higher rules.
Got it. Okay.
And in U.S. law, traditionally, Congress is the branch that holds or exercises this kind of authority in three historically really critical areas. Our sources really highlight these as the sort of the classic examples.
All right, let's name those three areas, because I suspect these are exactly the zones where the term is being, well, maybe weaponized in today's political fights.
Very likely. So
Okay.
first, you have interstate commerce.
Right, the Commerce Clause.
Exactly. Congress has essentially a complete, comprehensive power to regulate economic activity, the movement of goods, transactions, anything that crosses state lines.
And that's not just limited to, like, trains and trucks, is it? That power has been stretched pretty far.
Oh, incredibly broadly. Under the Commerce Clause, the interpretation has become so expansive that Congress can regulate pretty much anything that even affects commerce.
Yeah.
Which makes it one of the most powerful tools in the federal government's entire toolkit.
So if that clause is interpreted so widely, I mean, covering basically anything that touches trade, that single area of plenary power gives Congress this enormous, seemingly almost endless reach into the national economy.
It does. It really underscores why that specific power is so fundamental for, having a unified national market actually function.
Makes sense. Okay, what's the second core area?
The second one is immigration.
Ah, okay. Big one right now.
Huge. Congress is granted broad, historically really expansive power here. They determine who enters the country, who gets to stay, under what conditions.
And the justification for that level of power.
It's generally rooted in ideas of national sovereignty and security. The argument is that controlling borders requires singular federal control. It needs to be sort of insulated as much as possible from, state-level politics or even judicial interference to some extent.
And that, of course, is ground zero for the current political battles. Anytime the White House, the executive branch, acts unilaterally on border policy, they're implicitly leaning on this idea, right, that Congress granted them this plenary power in the immigration sphere.
That's often the underpinning argument, yes.
Okay. And the third example?
The third key example is Native American affairs.
Right.
The federal government, acting through Congress, holds nearly comprehensive authority when it comes to the very complex legal and governmental relationship with Native American tribes.
Where does that specific power come from?
It's rooted deep in history, in treaty obligations, court decisions, and the unique sovereign status that tribes hold relative to the federal government, but not to the states in the same way.
Okay, so those three areas, commerce, immigration, Native American affairs, represent the kind of maximum jurisdiction Congress can assert.
Generally speaking, yes. Those are the classic pillars.
So we have to immediately tackle the counter-narrative, the big but. How does the American system, which is fundamentally built on preventing too much concentrated power, how does it allow for something called plenary authority without basically becoming dictatorial? What's the crucial caveat here?
And you've absolutely hit on the most critical nuance. It's the part that often gets lost in the sound bites and the headlines.
Okay.
While the legal interpretation suggests one entity holds this complete jurisdiction, that power is never truly unlimited in a functioning democracy. It is always implicitly balanced. It's structured within the confines of the broader legal framework we have.
So the power is complete within its specific lane, but its exercise, how it's used, still has to be constitutional.
Precisely. That's the key.
So what are those constitutional guardrails specifically? What stops plenary authority from just running wild and becoming totalitarian rule?
The sources we looked at are very clear on this. This power is checked by two fundamental factors. The first one is pretty straightforward. Constitutional limits, meaning the entity exercising the plenary power, Congress, usually cannot, under any circumstance, violate the Bill of Rights or other fundamental constitutional guarantees.
Okay, so even if Congress has, say, complete power to regulate immigration,
right,
they still can't just decide to deport someone without any due process, for example.
Exactly right. The power governs the subject matter immigration policy, but the Constitution governs the procedure, how you implement that policy fairly.
Got it. Okay, that makes sense. What's the second check? You said there were two.
The second check, and this is arguably the most vital one in practice, is judicial review.
Ah, the court stepping in. Let's spend a moment on that, because judicial review really feels like the mechanism that anchors this potentially huge power, plenary power, to the actual ground of American law. How should we define judicial review in this specific context?
Well, judicial review is fundamentally the judiciary's power, its ultimate authority, really, to invalidate laws or executive actions if they're found to be unconstitutional.
Regardless of whether the power behind that law was labeled plenary.
Exactly. Regardless of its plenary status. So let's say Congress passes a law using its plenary power over interstate commerce.
Okay.
And someone challenges that law. They say, hey, this violates my First Amendment right to free speech.
Right.
The courts then step in. Now, crucially, they aren't questioning Congress's right to regulate commerce. That's the plenary part.
They accept that base authority.
Yes. What they're challenging is the manner in which Congress chose to exercise that right in this specific instance. Does the way they regulated commerce step on a constitutional right?
Okay. So the argument fundamentally shifts. It goes from, does the government have the right to act at all in this area? Which plenary authority often answers with yes, to, okay, they acted, but did they act fairly and constitutionally?
That's the perfect distinction. Think of it like this. Plenary power might give the government the right to build a road, right? That's within their scope.
Okay.
But it doesn't give them the right to seize private land for that road without paying fair compensation. That would violate the Fifth Amendment's takings clause.
I see. So plenary power grants the authority to regulate, but not the authority to regulate arbitrarily or tyrannically. The Constitution still sets the rules of engagement.
Precisely. And that is such a fundamental distinction. It really transforms the entire conversation around this term.
It really does. It shows that when politicians or commentators invoke plenary authority, maybe to justify a strong action, they're often invoking the broad power aspect, but they might be, perhaps strategically, leaving out the crucial constitutional and judicial limitations that are just baked into the concept within a democracy.
That happens quite a lot in the political rhetoric surrounding it. The limits get downplayed or ignored.
Right. Okay, so this is where it gets, for me, really fascinating. Connecting this concept, plenary authority, to the very architecture of U.S. governance. We understand the definition now and the essential checks. But let's trace it back. Where did this idea even come from? How did it get so deeply embedded in our constitutional system?
Yeah, to understand its origins, we really need to look back to the 19th century.
Yeah.
That's when constitutional law was really developing rapidly.
Yep.
And the courts back then were wrestling with two huge interconnected things. First, defining the separation of powers between the branches of government.
Makes sense.
And second, establishing the necessary supremacy of the federal government in certain key arenas over the states.
And plenary authority emerged from that.
Largely, yes. It was developed in many ways as a legal mechanism to support and affirm federal supremacy.
Can you elaborate on that? Why was there this historical need to use such a strong term like plenary to assert federal power?
Well, think about the context. Especially after the Civil War, the nation was industrializing, the economy was growing incredibly fast, becoming truly national.
Right. Railroads, telegraphs.
Exactly. Now imagine if every single state could impose its own completely different rules, its own regulations, maybe even tariffs on goods or people moving across its borders.
It would be chaos. It would paralyze national growth.
Utter chaos. It would grind everything to a halt. So the court started using the concept of plenary power, especially related to that Commerce Clause we talked about, to draw clear, basically unwavering lines of authority. Saying, look, in this area, interstate commerce, the federal government, through Congress, gets the final comprehensive say. Full stop.
So asserting federal supremacy using the language of plenary power wasn't necessarily about a power grab for its own sake.
Not entirely, no.
It was more about creating the predictability, the stability, the uniformity that was actually needed for the nation to function as, well, a single economic and political unit.
That was a huge part of the motivation, yes. It provided that clear, essential jurisdiction.
Without it, you'd just have constant fights.
Constant muddied waters. Endless federal-state disputes over who has the ultimate authority over the movement of goods or people or money across state lines.
And immigration fits into that logic, too.
Very much so. The courts argued pretty forcefully back then that things like national identity, who belongs, and foreign relations are inherently federal concerns.
Right. Not something individual states should control.
Exactly. And therefore, they required the most extensive, the fullest authority, plenary authority, for the federal government to be effective on the world stage and maintain national cohesion.
Okay, but this historical evolution, establishing strong federal power, must have clashed pretty directly with that deep American tradition of limited government, right? I mean, the founders were famously suspicious of centralized power.
Deeply suspicious.
Yes. So how did the legal minds of that era justify introducing a concept that sounds like absolute power into a system specifically designed to prevent concentrations of power?
Well, that's the ongoing tension, isn't it? It's never fully resolved. The justification fundamentally rested on the idea that this power wasn't just, like, grabbed out of thin air by the government.
Okay.
It was delegated by the Constitution itself. And because it came from the Constitution, it was therefore inherently subject to the Constitution's limitations.
So the source of the power also limits it.
In theory, yes. Chief Justice John Marshall, who was hugely influential in defining federal power early on.
Right, Marbury v. Madison and all that.
Exactly. He essentially established the idea that where the Constitution grants a power or assigns a responsibility to the federal government, that authority must be sufficient, must be strong enough to actually achieve its constitutional purpose.
And sometimes sufficient means comprehensive, means plenary.
Often, yes. especially for those big national tasks like regulating commerce or managing foreign affairs. The power had to be big enough for the job.
So the power is as big as it needs to be to get the constitutionally assigned job done, but crucially, no bigger than the Constitution itself allows.
That's the ideal balance, yes.
Okay, let's try and ground these limitations again, but with a strong historical example of the courts actually stepping in, bringing that historical precedent forward a bit.
Sure. A really classic historical example comes from that area of Native American affairs we mentioned.
Okay.
While Congress clearly has extensive plenary power in that domain, the courts have intervened repeatedly over the years. For instance, they've established and enforced what's called the trust responsibility.
The trust responsibility.
Yes. It's the idea that the federal government has a special duty, like a guardian or trustee, toward the tribes because of that historical relationship and the treaties. So if Congress, even using its plenary power, passed legislation affecting tribes that was seen as fundamentally arbitrary or that violated these implicit duties of the federal government as guardian,
then the courts would step in.
the courts would assert that the exercise of that power, even though rooted in a plenary grant, was unconstitutional in that specific application. They'd strike it down or modify it.
Okay, or let's circle back to immigration again.
Yeah.
While Congress has broad power to decide who enters, who gets excluded,
Right, that plenary power.
the Supreme Court has still made it clear over time that the procedures used for exclusion or deportation have to respect basic constitutional fairness, right? Specifically, due process.
Absolutely. Due process is a key limitation. If the government decided, hypothetically, to deport an entire group of people based on, say, their origin, without giving them any kind of hearing or chance to present their case.
That judicial check immediately kicks in.
It should, yes.
Yeah.
The courts would likely find that action unconstitutional, even if Congress claimed it was acting under its plenary immigration power.
So the power to regulate the subject is plenary, but the fundamental duty to govern fairly always remains paramount.
That's a perfect summary. The court typically doesn't second-guess the policy choice made under plenary power, like, should we restrict immigration this way or that way?
Right, that's seen as Congress's job.
But it rigorously, or at least it's supposed to rigorously, examine the process, the how. How is that policy implemented? Was it fair? Was it constitutional?
And understanding that difference is absolutely essential, isn't it? The difference between the strict legal definition of plenary power and the often much looser, maybe more absolute way it gets thrown around in political arguments.
Critical insight, yes. It shifts the whole debate from just accepting or rejecting the existence of the power itself to scrutinizing carefully the specific way that power is being used in any given situation.
Which brings us right smack into the present moment. Why now? Why is this relatively obscure, centuries-old legal phrase suddenly lighting up headlines, becoming trending content right here in 2025?
Because, fundamentally, those three core areas where plenary power traditionally resides, commerce, immigration, Native American affairs, and related areas touching on executive power and even elections. Those are precisely the areas where American society and our government are currently experiencing maximum stress, maximum conflict.
So the term bubbles up when the lines of power are being pushed.
Aggressively tested. Exactly. That's precisely what's happening right now across these key battlegrounds. The term reemerges whenever the fundamental distribution of authority is being challenged.
Okay, let's break those down. Let's start with the executive branch. I mean, the debate over presidential power, executive orders, agency actions, it feels like it's been running nonstop for years now.
It really has.
How does plenary authority play into arguments about the limits of the White House or federal agencies?
Well, a lot of the recent legal fights, the ones our sources point to, revolve around the extent of the executive branch's delegated authority.
Delegated from Congress.
Yes. Congress often passes these huge, sometimes quite general laws. Think about national security or environmental protection or responding to a big crisis like a pandemic.
Okay.
And in those laws, they essentially delegate broad authority to federal agencies, or sometimes directly to the president, to actually manage the specifics, fill in the details, make the rules.
Right. Congress sets the goal. The agencies figure out how to get there.
Sort of. But the big constitutional question becomes, when Congress delegates that vast authority, maybe in really vague terms, is it effectively creating a kind of pocket of plenary executive power? A zone where the president or an agency can act almost without check because Congress didn't draw clear lines.
So Congress itself might not claim plenary power, but its actions or inactions could create something that functions like it in the executive branch.
That's precisely the concern. It raises really serious questions about something called the non-delegation doctrine. The idea that Congress can't just give away its core legislative power.
Because if Congress is too vague,
then the executive branch might interpret that vague delegation as granting them near absolute power within that specific regulatory space.
Yeah.
They might say, Congress told us to achieve X, they didn't say how, so we can do almost anything to get there.
And the courts have to step in and referee.
Constantly. The courts are forced to ask, did Congress really intend to grant this quasi-plenary power? Or is the executive branch maybe exploiting ambiguous old laws to push the boundaries of its actual delegated authority way too far?
And the Supreme Court cases we mentioned earlier are tackling this directly.
Some of them are, yes, trying to define whether certain executive actions, maybe based on statutes passed decades ago, are now operating under a kind of unchecked plenary-style power that wasn't originally intended.
So this is really interesting. The modern controversy isn't just about Congress claiming plenary power for itself,
Right.
but also about the executive branch potentially claiming a kind of derivative plenary power based on what Congress didn't say or delegated too broadly.
That is a perfect way to articulate the modern problem. Yes, if a president claims the power to unilaterally set major policy maybe on trade or the environment because Congress didn't spell out specific limits in a law from, say, 50 years ago.
Yeah.
That action immediately gets scrutinized. People ask, is this overreach? Is this too much concentrated power, effectively bypassing the legislative process?
Okay, let's shift to the second major battleground you mentioned, immigration and border control. This is obviously incredibly charged emotionally and politically.
Always is.
And you said this is where that historical precedent of federal plenary authority is being openly challenged now from different directions.
Yes, it's being challenged from multiple angles. It's really multifaceted. On one side, you have numerous states, particularly border states, arguing that the federal government is actually failing to exercise its plenary power effectively.
How so?
Their argument is often that by, in their view, not adequately securing the border, the federal government is essentially imposing an unfair burden on state resources, schools, healthcare, law enforcement.
So they're saying you have the power, use it, or maybe even if you won't use it, let us.
Something like that, yes.
Yeah.
It's a challenge based on perceived federal inaction or ineffectiveness within its sphere of authority.
Okay. But then there's the other side of the challenge.
Right. Whenever the federal government does act aggressively, maybe through large-scale deportations or new restrictions on who can enter or how asylum claims are processed.
So then the challenges come from individuals and rights groups.
Exactly. Opponents immediately argue that the exercise of that plenary power, even if the power itself exists, is violating fundamental constitutional guarantees, due process, equal protection, maybe even international norms.
And that triggers the judicial review check we talked about.
It's supposed to, yes. That's when the lawsuits fly, arguing the way the power is being used is unconstitutional.
So, wow. The plenary authority in immigration is getting squeezed from both sides. States challenging what they see as federal failure or underreach, and individuals and groups challenging federal actions as overreach or unconstitutional application.
It creates this tremendous constant flashpoint. Every time the federal government asserts its historical right to act unilaterally at the border, citing its plenary power, the opposing side immediately raises the alarm about the dangers of concentrated, potentially unchecked power. It taps right into those deep fears about government overreach.
And that directly fuels the tension over federalism, doesn't it? That core conflict. We need a strong federal government for national issues like borders, but we also value local control and worry about Washington having too much power.
Precisely. It reignites that fundamental debate every single time.
Okay, and the third area you mentioned where this is flaring up now is election law. Disputes over state versus federal control. How does plenary authority fit in there? Because usually we think of states running elections, right?
Traditionally, yes.
Yeah.
States have historically held significant authority over the mechanics of how elections are conducted within their borders. Generally, it's not considered a classic federal plenary power domain like immigration or commerce.
But something's changing.
Well, the modern debate, especially in recent years, centers on whether federal legislation, or perhaps broad court rulings, should step in to standardize certain key election practices across the whole country.
Standardize things like what?
Things like voter ID requirements, rules around mail-in ballots, voter registration standards, maybe even the types of voting machines used, access to polling places. those kinds of procedural nuts and bolts.
And if the federal government did step in to create, say, a uniform national standard for voter registration,
Right.
they would essentially be asserting a kind of superior, maybe even plenary power over that specific aspect of election mechanics, overriding potentially dozens of different state systems.
Exactly. That's the conflict. It becomes a collision between the traditionally established state authority in running elections and an asserted federal authority.
Where would that federal authority come from?
Often, the argument is rooted in constitutional guarantees, like the Equal Protection Clause of the 14th Amendment, arguing that different state rules create unequal access to voting, which the federal government has a duty to fix, or perhaps invoking the federal power over federal elections specifically.
So the fight becomes who ultimately holds the complete decision-making authority for certain crucial parts of election administration. Is it the state, or can the federal government step in and dictate terms?
That's the crux of it. It's a direct, very modern expression of that plenary power conflict, even if the term plenary isn't always explicitly used in the election context.
And the Constitution itself is maybe a bit ambiguous on the exact lines here.
It leaves some room for debate, yes.
Yeah.
Which creates fertile ground for these intense political and legal clashes over who's really in charge of the voting process.
Okay, so summing up this section. The term plenary authority isn't trending because the concept itself is brand new.
Not at all.
It's trending because the foundational authority in these critical, sensitive areas, executive power and delegation, immigration policy, and now even election mechanics, is under intense, aggressive litigation and political assault from multiple directions.
That's a very good summary. And what's really fascinating, politically and culturally, is how the debate around this term, plenary authority, reveals this major split, this schism, in how people think about government power today.
Oh, so.
When people hear that phrase, plenary authority, they almost immediately seem to sort themselves into one of two distinctly opposite philosophical camps. And it's important we try to lay out both of those perspectives impartially.
Okay, let's do that. Let's frame these two sides based on the core values they seem to prioritize.
Right. So on one side, you have what we could call the pro-plenary view, or maybe the necessary power view.
Okay. What are their main arguments?
These arguments tend to suggest that plenary authority isn't just, constitutionally permissible in its historical context, but that it's often actually necessary for effective, decisive governance in the modern world. Their core value here seems to be efficiency, effectiveness, unified action.
So their big worry is gridlock, that without one body having the clear, final, comprehensive say in certain areas, the whole system just grinds to a halt.
Precisely. They argue that especially in really complex policy areas, think international trade negotiations, or managing a pandemic, or responding to a sudden national security threat.
You need speed and unity.
Swift, unified action is essential. Having to wait for 50 different states to agree, or for endless debates across multiple congressional committees, can be paralyzing, even dangerous in a crisis.
So they see concentrating power in these defined areas not as a bug, but as a feature, a necessary tool.
Essentially, yes. A necessary tool to ensure the government can actually function effectively and avoid stagnation, particularly in those critical fields like border control, national defense, or managing the national economy through commerce regulation.
The trade-off, in their view, is worth it. Maybe a little less state or local control, but you get a much more functional national government capable of acting decisively when needed.
That's often the argument. They might point to the sheer complexity of the modern world, arguing that governmental power, particularly federal legislative power, simply has to be broad enough, comprehensive enough to handle challenges that the 18th century framers just couldn't have possibly imagined.
Okay, that's one side. But then you have the view that's basically the polar opposite, right? The anti-plenary view.
Exactly. And this perspective tends to prioritize values like accountability, liberty, and preventing government overreach above pure efficiency.
What's their core concern?
They view plenary authority almost by definition as inherently dangerous. Regardless of those constitutional guardrails we talked about, the Bill of Rights, judicial review.
Why inherently dangerous?
Their primary worry is the potential for abuse and government overreach. They argue that the very comprehensiveness of the power, the complete and absolute part, even within its scope, makes it incredibly difficult for the public, for the press, maybe even for other branches of government, to effectively scrutinize the decision makers.
It feels too opaque, too powerful.
Yes. And this perspective taps right into that deep-seated American suspicion of centralized authority we mentioned earlier. It views almost any form of complete power as inherently threatening to individual liberty and the democratic system of checks and balances.
So the argument becomes, if the power to regulate immigration is truly near absolute in scope, how do you realistically prevent abuses, especially when policies might target vulnerable groups who lack political power? It raises that fundamental question.
It absolutely does. And from this perspective, every single assertion of plenary power, whether by Congress or the executive branch, should be met with intense scrutiny and rigorous judicial skepticism. The courts need to be extra vigilant.
So the term plenary authority itself becomes more than just a legal definition.
It becomes the academic label, almost, for this visceral, ongoing conflict in American thought. The clash between the undeniable need for governmental capacity to solve big problems and the equally undeniable need for governmental restraint to protect individual freedom and prevent tyranny.
And that fundamental philosophical divide, that tension, is what really pushes this dry legal term out of the law books and courtrooms.
Exactly.
And onto social media, into news headlines, making it trend. Which brings us to the cultural trend itself, this whole explainer economy that seems to pop up whenever a complex issue hits the mainstream.
Yeah, this movement of information or attempted understanding is really fascinating to watch. The digital sphere, the platforms like TikTok, Twitter, X, YouTube, they specialize in rapid dissemination.
Getting info out fast.
But maybe more importantly, they specialize in the translation of complex information into more accessible formats.
Right. Breaking it down.
So when plenary authority started dominating those high-profile Supreme Court cases or fiery political debates, the general public had this immediate need, or at least curiosity, to understand what was at stake. What does this term actually mean for me, for the country?
And what they found online was this huge wave of content trying to do just that, trying to break down this dense legal language.
A massive wave, yeah. We're talking about journalists, established legal commentators, but also, interestingly, amateur creators, students, regular people using short-form video, threads, blog posts.
To tackle concepts usually saved for like a con law seminar?
Exactly. Tackling stuff usually reserved for law school. Our sources specifically mentioned the explosion of content using these really approachable analogies or titles like Plenary Power 101 or Plenary Authority Explained.
What kind of analogies do they use?
Well, creators often try to use real-world comparisons, like maybe comparing the government's specific plenary power to the complete sort of plenary authority a landlord might have over managing their commercial building. But, and this is key, they immediately have to add the caveat. But that landlord still can't violate local housing codes or fire safety regulations or anti-discrimination laws.
So the analogies try to show both the scope of the power, you control the building, and the external limits. But you still have to follow these rules.
Precisely. The goal of the good explainers is to demonstrate both the breadth of the power and its constitutional limitations simultaneously.
It's interesting, isn't it, that the sheer complexity seems to be part of the draw. It feels like there's a real public appetite right now for understanding the actual mechanics of how power works, not just the surface-level political spin.
I think you're right. People want to know the rules of the game, especially when they feel like the stakes are incredibly high. They want to understand the structures that govern their lives.
And this widespread dissection, this attempt to understand, leads to the term's final kind of modern role. It becomes a powerful symbol.
Yes. Plenary authority has really become shorthand, hasn't it? Shorthand for these much broader, often quite anxious, cultural debates about control. Systemic control, abstract control, especially in our complex digital age.
How do you mean?
Well, think about it. When people feel powerless, maybe against sweeping government mandates they don't understand, or against huge proposed regulations for the tech industry, or even against the sort of unseen power wielded by massive corporations, the underlying tension, often unspoken, is always about who holds the ultimate, maybe unimpeded decision-making power in this situation. Who's really in control here?
And plenary authority captures that fear of unchecked control.
Precisely. It could symbolize the very mechanics of power, almost regardless of who holds it, whether it's Congress asserting authority over commerce, or the executive branch acting on national security, or maybe, hypothetically, some powerful new regulatory body overseeing AI or the digital space.
So the term itself becomes a vessel for anxiety.
It's the perfect term, in a way, to summarize that general anxiety many people feel when they perceive power consolidating somewhere, seemingly without sufficient checks or transparency, whether that consolidation is happening in Washington, D.C., or maybe even in Silicon Valley boardrooms.
The core concern remains the same. Who has that complete jurisdiction and, crucially, who can reliably hold them accountable?
Exactly. That accountability piece is key.
Okay. So we've traced plenary authority all the way from its dense legal definition through its historical role in shaping federal power. We've looked at the absolutely necessary constitutional checks.
The guardrails.
The guardrails, yeah. And finally, we've seen how and why it exploded onto the digital stage as a major buzzword in 2025.
It's been quite a journey for one legal term.
It really has. So let's bring it all together. What does this entire analysis really reveal about our system of governance today? And maybe most importantly, why should you, our listener, care about this seemingly arcane legal concept?
Well, I think fundamentally, it reveals that the language of power is always critically important. How we define authority, how we talk about it, matters immensely.
Okay.
The sudden trends surrounding plenary authority isn't just noise. It's actually a powerful signal. It tells us something important about the power dynamics shifting within our modern systems.
What does it tell us?
It forces us, I think, as citizens, to constantly examine where control truly lies. How comprehensively is that control being exercised? And are those constitutional guardrails we discussed, especially judicial review, are they actually holding fast? Are they strong enough against this inherent urge, maybe, towards seeking complete and total authority in certain areas?
So it reveals that constant, maybe necessary tension that's just built into our system.
Exactly. The tension between needing strong, sometimes unified government power to tackle big national problems.
Right, the efficiency argument.
Versus the fundamental democratic imperative to limit that power, to check it, to protect individual liberties and ensure accountability.
And the digital age just pours gasoline on that fire.
It absolutely amplifies the tension. It allows these high-level, complex legal debates to instantly become public political crises, spreading fear and confusion sometimes faster than understanding.
So understanding a term like plenary authority isn't just academic.
Not at all. It allows us, hopefully, to move past the immediate, often heated political rhetoric and actually analyze the mechanism of power that's being employed or debated.
And crucially ask,
is that mechanism being adequately subjected to those checks, to judicial review, to constitutional limits? Without that deeper understanding of the mechanism itself, we can't really have an effective debate about accountability. We're just shouting about the outcomes.
That's really empowering knowledge, isn't it? Just knowing that even if a branch of government claims complete and absolute power over one specific area, they still have to play by the basic rules of the game. The rules defined by the Constitution and, in theory, upheld by the judiciary.
Indeed. It's a crucial reminder that judicial review isn't just some abstract theory from a textbook. It's meant to be an active, critical function in our democracy, ensuring that even comprehensive plenary power doesn't morph into arbitrary or tyrannical rule.
That is a really fundamental insight to end on, and it leaves us, and you, the listener, with a final provocative thought to maybe chew on. If effective governance in our complex world truly does demand some measure of complete authority in certain areas, where exactly should we draw the line? How much is necessary before that very necessity starts to compromise democratic accountability itself?
That's the billion-dollar question, isn't it? It's a question that really defines so much of our political era, and it will undoubtedly continue to fuel legal battles and public debate for years to come.
Next time on Trending Unpacked, we'll turn to the man who defined cinematic control, Alfred Hitchcock, and explore how his legacy still shapes storytelling and suspense today.